He thinks that his case is too publicized to get a fair trial. So let's go over these documents and give our reaction. All right. So here we have in the United States District Court, District of Massachusetts. Remember, this is a federal case, and this case is not going to be live streamed. All right. Leave to file excess pages granted on November 14th, 2025. Docket entry 70, filed on November 17th, 2025. Motion to transfer venue. All right. Much like the right to counsel, the right to remain silent, and the right not to have the evidence misstated or manipulated, the right to be presumed innocent unless proven guilty is a specific right afforded to the accused under United States Constitution. Pagano versus Allard, Massachusetts 2002, citing Darden v. Wainwright from 1986. Matthew Farwell, through undersigned counsel, pursuant to 5th, 6th, and 8th Amendments to the United States Constitution and the Rule 21 of the Federal Rules of Criminal Procedure, moves this honorable court to transfer venue from the District of Massachusetts as set forth below, due to the saturation of prejudicial local publicity. There is a reasonable likelihood that prejudicial news coverage prior to trial has and will continue to prevent a fair trial in this district. And I think that he could have a decent argument. The thing is, they were able to find a jury in Karen Reed twice, which Sandra Birchmore's case, even though it should be more publicized than it is not as publicized. Now, do the locals know about these things? Yes. I don't know if everybody in the county does. We shall see. Case background. In early February of 2021, Sandra Birchmore unalived. Her body was discovered in Canton, Massachusetts, apartment by local law enforcement on February 4th, 2021. The Office of Chief Medical Examiner for the Commonwealth of Massachusetts, OCME, conducted a full autopsy on Birchmore. The OCME determined that Miss Birchmore's cause of death was asphyxia by hanging and that her manner of death was unaliving. A lengthy investigation by the Massachusetts State Police Detectives Unit assigned to the Norfolk County District Attorney's Office of Miss Birchmore's death and the events leading up to it resulted in no criminal charges. Indeed, no person has been charged by the Commonwealth of Massachusetts with any wrongdoing in the death of Miss Birchmore. The official cause of death on her death certificate remains to this day unaliving. See Exhibit 1. The thing is, that is now a question for the fact finders. And this is written from the defense's side. So the defense is saying, no, she is the one who unalived herself. Where the feds are saying, no, she did not. You murdered her, Farwell. And what is different in this case than in a lot of other cases is that the ME is now not changing her death certificate, and they've had somebody in-house again, I believe, look at it for a second time. No, that was a different case. Okay, they're still not changing it. And the Commonwealth in Norfolk isn't charging Farwell as of right now. But we have to remember Farwell is a former police officer. And we know what Norfolk likes to do: protect their own. So I'm sorry. y- I don't like this argument. This is how they are going to be presenting their facts to the jury. I don't know that a jury is going to buy this, no matter what venue or where they try this trial. I don't think it's going to matter. But he's given it the old college try. On August 27th, 2024, 3.5 years after Birchmore unalived, the United States filed a one-count indictment purporting to allege the unlawful killing of Miss Birchmore. Mr. Farwell entered plea of not guilty to the accusations against him. On October 28th, 2025, the United States filed a two-count indictment alleging both the unlawful killing of Miss Birchmore and the death of her fetus in utero. Mr. Farwell will plead not guilty to the superseding indictment on November 21st, 2025, and exercise his fundamental right to a jury trial. Mr. Farwell contests guilt in this case. Well, good for him. As demonstrated herein, the one-sided biased media coverage has led to widespread public misbelief that Mr. Farwell is guilty of abusing law enforcement position of trust, of grooming Miss Birchmore and having sex with her while she was a minor, and then ultimately killing her and staging the scene to look like a suicide. The thing is they have put out what texts have said, um, and so forth. Now, if it comes out that all those texts are fake, okay. You're also going to have to explain to us the whole you being there and what others have found in the autopsy, and that the way she was living her life just didn't align with that. Could it be that all of a sudden she was planning all of this and then he came over that night and yeah, she got a car seat during the day, but after he just broke up with her, that was it. And she just felt like she couldn't do it without him. But I think she knew she was going to have to do it without him because of how he was. So I don't think she expected him to necessarily be an active participant. Would she want him to be? Yeah, at least in the child's life. Granted, it would have come out that he is not the father, that um and so that wouldn't be there, but I we'll have to see. And sadly this isn't going to be live stream. And so the only way for us to know things is through the court documents and reading his side of the story, as well as the Commonwealth side of this, or not the Commonwealth, I guess the state's side of things, to see what we believe, since we're not going to be able to live stream it. And then we have to take the word of the media that reports on things, um, which I hate doing, but sometimes that's all we're left with if we don't have boots on the ground, trusted boots on the ground. The issue of whether the prosecution can prove beyond a reasonable doubt that Miss Birchmore's death was a homicide as opposed to an unaliving, that it was, should be tried in a court of law, not the court of public opinion. I agree, and I believe that's what we're doing. Significantly, the defense cannot defend Mr. Farwell in the press as both the local rules for the District of Massachusetts and the Massachusetts Rule of Professional Conduct forbid public comment about the evidence. See footnote 1, Mass Rules of Professional Conduct and the local rules. Okay. Consistent with these rules, undersigned counsel have repeatedly refused to participate in the process. Good. You're doing your job as a defense attorney. You should be focusing on fighting it in court. I do agree with that. And then we should all want Farwell to have the best representation so that if and when he is convicted and found guilty, he does not have anything to appeal and to get out and see the light of day again. We want him to have the fairest of the fair trial so that there are no technicalities of him getting out or getting another shot at this. Do it right the first time. Docket entry 9-1. On August 27th, 2024, the sealed indictment was filed as a docket entry 1 against Matthew Farwell on August 27th, 2024. An arrest warrant issued for Matthew Farwell on August 28th, 2024. The government filed a motion to unseal the case. This was granted the same day just after Mr. Farwell was arrested. Also, that same day, the government filed a motion for detention along with an affidavit by the FBI agent, CDE 991. The 45-page FBI affidavit filed by the government before Mr. Farwell was represented by counsel detailed a cherry-picked version of alleged quote-unquote facts and a one-sided narrative against Mr. Farwell. The contents of the affidavit containing headlines and derogatory inflammatory characterizations of Mr. Farwell, multiple levels of hearsay, and other substantial grounds for objection have not been ruled admissible by the court. Yeah, I agree with that. Not everything that is released to the public is going to be in a court of law. Is it part of the story? Yeah. And it can help us form a better opinion. But yeah, there's a lot of hearsay out there. But I believe they'll be able to prove this case without all that hearsay. Additionally, or wait, let's go to footnote 2. Sorry. Should this case be transferred to another district, the defense would move to seal Exhibit 9-1 to prevent further prejudicial publicity in the subsequent venue. I am not sure. I think we've already gone over that. So I don't know how much of a difference that's going to make. Additionally, at 1:55 p.m. on August 28, 2024, the Boston Globe ran a story about the unsealed indictment called What to Know About the Sandra Birchmore Case, Exhibit 2. Thus, the press was aware of the docket filings and had the 45-page FBI affidavit available to them before Mr. Farwell even had an attorney. At DE 10, Magistrate Judge Kelly appointed the Federal Defender Program through attorney Sandra Gant to represent Matthew Farwell. The arraignment was set for August 28, 2024 at 2:30 p.m. A copy of the motion and accompanying FBI affidavit was not served on Ms. Gant at the time of her appointment. In less than 24 hours, the seeds of damage to Mr. Farwell's right to a fair trial were sown. By 6:03 a.m. on August 29, 2024, the Boston Globe published a story referring to the details of the FBI affidavit and discussing, among other things, digital communications alleged to be between Mr. Farwell and Miss Birchmore. See Exhibit 3. Is he going to say that these conversations are not between him and Birchmore? That it's not him? That somebody else did this from his devices? That's okay. I mean, they are technically alleged right now because we haven't had trial, but really? That's where you're going to put alleged in? That Farwell didn't allegedly do these digital communications? That's just made up stuff that the feds put in their documents? That seems disingenuous, and I'd be really pissed off if the feds were doing that. To be fair, I don't think they are. Important principles to keep in mind when analyzing the press coverage here are that publicized quote unquote facts may be untrue, statements referenced in the reporting may ultimately be inadmissible, photographic and videotaped evidence may be unreliable, and witnesses may substantially modify their stories under oath or after confrontation and cross examination. I agree. There are things that won't be able to come in. Um, I would like to know what photographic or videotaped evidence is unreliable. Are they saying that the video surveillance footage from Farwell visiting Sandra Birchmore that night is unreliable? That any of the photographs that are out there right now are not real? I get the inadmissibility and that witnesses could change their story or say other things and we might learn more. Um, I still don't think it takes away that he did what he did. Um, as set forth below, Mr. Farwell has demonstrated a reasonable likelihood that prejudicial news prior to trial has prevented a fair trial in this district. So I don't know what district they would go to. Once again, I don't think it's going to matter what district this is tried in. Local press coverage. By its own account, the Boston Globe is one of the world's most prestigious daily newspaper with a cumulative reach of over 1 million readers. See footnote 4. The Globe's social media X account boasts 774,100 followers. Exhibit 4. In January 2025, Boston Globe Media acquired Boston Magazine from Philadelphia-based publisher Metro Corp, adding a regional news portfolio that includes the Boston Globe, Boston.com, and Stat News. See footnote 5. For a media company with such reach and roots, it should be more than concerning that it is also steadfastly and insistently displayed its bias in its reporting on the death of Sandra Birchmore in the allegations against Mr. Farwell. Well, the thing is they're only going off of what they have. And I get it. That can be prejudicial to your client, and people can find out about it. But we haven't seen much from Farwell's side. We haven't seen many filings from Farwell's side. So we don't have Farwell's story, even in court documents necessarily. I want to know what his side is so that I can use my BS barometer and make, my own conclusions based on what your side of the story is. We just don't have your side of the story. And I get you're choosing not to talk to the media, but we could be able to get his side in public court filings. That's where your side can get out to the people as well. I'm not saying it's still not going to be biased, but at least your side would be out there as well. The Globe has consistently reported on government's one-sided narrative from the 45-page FBI affidavit as the quote unquote facts of this case. See footnote 6. Comments. Okay, so these are the footnotes from what I just read. Comments to this story. People should read the affidavit for the FBI agent in support of pretrial detention. It's hideous and horrifying. No hyperbole. It literally should be the worst thing you have ever read about a police officer. At 9:50 a.m. that same day, a reader posted a link to the affidavit. Within minutes, the same reader posted the affidavit document Matthew Farwell's having choked Sandra Birchmore multiple times. Choking is a common predictor of homicide in abusive relationships. See Exhibits 3 at 31 through 32. 4, 2024 Boston Globe Media, General Media Kits. Okay. 5, acquires Boston Globe Media acquires Boston Magazine. 6, the Globe has been a recipient of at least 2 national awards for its coverage of this case. In one journalism competition held by the University of Colorado at Boulder, the press release claimed that the Globe's reporting demonstrates that OCME's conclusion of suicide was wrong and that its dodged pursuit of the truth led to the we got to go at the bottom of this. Federal prosecution of Matthew Farwell for alleged killing of Miss Birchmore. Sandra Birchmore's death was ruled unaliving until Laura Cromaldi, a reporter with the Boston Globe, started digging into her past, including her history with Matthew Farwell, then a police officer. Her relentless pursuit of the truth resulted in secrets and lies, which led to this case being reopened and Farwell being charged in Birchmore's killing. Exhibit 5 at 1 and 2. In winning her first award, the Globe journalist on Sandra Birchmore's story, Laura Cromaldi, said, "It bothers me that there were people who had the authority and the means and the methods to get to the bottom of this, and they just didn't seem too interested in doing it. And by using my superpower, which is to put things in the newspaper, I could make a difference. And I wanted to do that." This is not her whole statement. As we can see, there's ellipses in there, which means we're just getting snippets of what she has said. ID at 2, emphasis added, indictment of the impact of the Globe's reporting on the average reader, a judge of the media contest that awarded the Globe and the Al Nakula Award for Police Reporting Award said the story of Sandra Birchmore killing makes me sick to my stomach. Outraged. Emphasis added. In winning the Ed R. Murrow 2025 Feature Reporting Award for the investigative reporting in Sandra Birchmore's death, red flags missed, evidence overlooked, trust broken. The editor of the Boston Globe noted on August 15, 2025, that we are also gratified to see the recognition for the outstanding reporting behind her Sandra Birchmore reporting, which was an investment in uncovering the truth for her. Please tell me these footnotes do not go on. Is this part of a footnote too? Okay, I think okay. Alright. Alright, so where are the footnote? Alright, back to the document. A closer examination of the Globe's reporting further underscores the unavoidable impact on potential jurors in this district. In reviewing the press coverage, it is important to note that in assessing a motion for transfer of venue, the defendant must show a reasonable likelihood that prejudicial news prior to the trial will prevent a fair trial. Yeah, but who else? I get that, millions of people. But how many people in this area are reading the newspaper? There's a lot of people who don't read the newspaper and don't read articles, especially when they're behind a paywall. It's not like the paper that shows up on your front door anymore. Times have changed. In reviewing the press coverage, it is important to note that in assessing a motion to transfer a venue, the defendant must show a reasonable likelihood that prejudicial. Okay. See section 2 below, factors that the district court may take into account, including inter alia. The extent to which the government is responsible for generating the extent to which the publicity forces on the crime rather than on the individual defendants charged with it, and other factors reflecting on the likelihood or likely effect of the publicity on the ability of potential jurors in the district to hear the evidence impartially. United States versus Maldonado Rivera, Second Circuit, 1990. The press coverage here has most certainly stemmed from the FBI's one-sided narrative, focuses on Mr. Farwell's impermissible character, Mr. Farwell, and broadcast facts and images that will most certainly impact the ability of potential jurors in the district to hear the evidence impartially. Since April of 2022, the Boston Globe has run at least 77 stories involving Matthew Farwell and 52 stories that substantially reference him or this case. Exhibits 7 and 8, one 18-page long single-space story referenced above the fold on the front page of the Boston Sunday Globe, December 29, 2024, and inserted in Global Magazine, was titled, Sandra Birchmore Put Her Trust in the Police, They Broke It. Exhibit 9. Exhibit 9 should be read in its entirety to understand the prejudice that attaches. Just some examples of the prejudicial content revealing a one-sided narrative that draw the reader to conclude that Mr. Farwell is guilty. I mean, he just might be. But I get what they're saying. The investigations, charges, and recollections tell a story that is, in some ways, strikingly familiar. An alleged predator chooses his victim well before she had the capacity to know what was happening to her and leveraged her vulnerabilities against her for a decade. The damage done to Birchmore left her open to the exploitation by others too. But there is more here. The immense power imbalance that Birchmore endured in her life persisted long before she was gone. Time and again, investigators gave the benefit of the doubt to the police officer now accused of killing a young woman who was rarely, if ever, granted the same consideration. Experts on child SA abuse see this often, where victims abused by one person will then go on to be used by others and may even seem to enter into other exploitative relationships willingly because grooming normalizes those behaviors. At 9:08 p.m., Farwell asked if he could, quote unquote, come by for a second. After all, he was already close by. He walked into the lobby a few minutes later, less than a week later. Farwell would tell a state trooper He had gone there to tell her the baby wasn't his and to end the relationship, to say, quote unquote, it was over. After 29 minutes, the lobby camera picked up Farwell again, coming off the elevator, passing through the front doors, and walking out into the darkness. Are you saying that's not what happened? Is that prejudicial? Or is that what happened? Just asking. Later that day, Farwell apparently had second thoughts about cooperating. Using his department issued phone, he made 2 Google searches, according to the federal prosecutors. First, he wrote and then deleted. Can deleted iMessages be recovered by Celebrate? Celebrate makes tools that help investigators study data from mobile devices. Then, rethinking the form he just signed, Farwell made a second search. Can you revoke consent in Massachusetts? He deleted that question too. Well, did he? Because the thing is you're not, I mean, you did argue that some of the things seem to be untrue. But for the most part, you're mainly arguing that the things out there are just so prejudicial. And yeah, sometimes things are prejudicial. Records show that troopers did, in fact, seek Farwell's DNA shortly after Birchmore's death. If they had obtained it, they could have compared it with samples from Birchmore's clothing, her fetus, and the ligature around her neck, for example. But by March 8th, Farwell was done cooperating with police. He refused to provide a DNA sample. That has now actually been changed, I believe, that they did get a DNA sample and it is they did test the fetus. I don't know if they tested anything else, but they at least tested the fetus and found out that it was not Farwell's baby, is what reports have been. Now, it has not been presented in court, but that is what the reports have shown. And I am here just reporting on what we know and court documents. I am not saying that everything that anybody has said in these things is true. This is just what the story is currently. And as more information comes out, as the trial happens, we will be able to make a further, more informed opinion on our thoughts about this case. I don't know if anything is going to change our opinion, but it could. If there's some surprise thing out there. This past June, Dr. Michael Batten, the forensic pathologist hired by members of the Birchmore family to review the state medical examiner's determinations, made an explosive finding. This was a case of homicide, he said. Soon, another expert, hired by the federal investigator, Dr. William Smock, came to the same conclusion. I wonder how many more would come to that same conclusion. But the one that works for the Commonwealth is the only one that is saying that it is unaliving. Perhaps the most ominous evidence came when the FBI looked at the health app on Birchmore's phone, which tracks her steps, an analysis that does not appear to have been done by state police. Okay, once again, state police in that area, Norfolk, not doing their investigations very well when it comes to cops. The last movement it recorded was 8 steps around 9:40 p.m., a few minutes before Farwell was seen leaving the building. I mean, you can try to argue that she was just sitting on the couch when you left. But the thing is that from that 9:40 time, a few minutes before Farwell left, she never moved again from where she was sitting. So she never moved, at least with her phone, to grab the strap and do all the things to do this. She did not have her phone on her to do any of this. She set her phone down wherever it was gonna be and then did this because it doesn't show any movements. I mean, it's a possibility. Do we think that's true? Probably not. The article features a photograph and unequivocally states that it shows Matthew Farwell entering Miss Birchmore's apartment building on February 1st, 2021, the last day the Globe maintains that she was alive. See footnote 7. Well, she never touched her phone again, sir, after this. So are you saying this is not true? That's the thing. You're not saying any of this is untrue. I mean, you're trying to allude to maybe it's not. All right. So footnote 7. One example of bias in the reporting is illustrated. A Globe article published on June 12, 2025, written by columnist Yvonne Abram, along with the Globe staff Laura Grimaldi and Gordon Russell. This article discusses DNA testing results that two unidentified sources note that Mr. Farwell is not the father of the fetus that was carried by Miss Birchmore. The article then offers rampant speculation on the impact of the purported facts on the ultimate trial jury, reporting that the damage to the government's case could be minimal. Exhibit 10 at 3 emphasis. The story reprints the large photograph attributed to Mr. Farwell, that from what it claims is a video camera footage from lobby of Miss Birchmore's apartment building on the last day she was seen alive, minutes before he left the building. Birchmore's cell phone, usually in constant use, stopped moving and stayed motionless until its battery drained and her body was discovered 3 days later. Do we know where her phone? I don't even remember. Do we know where her phone was found? Was it found next to her? Was it found in the living room? The bathroom? Like, where was her cell phone found? Because that would be an interesting thing, too. The story, likely the overall reporting in this case, skews in favor of the government friendly narrative. See also Matthew Farwell refused to provide DNA to detectives investigating Sandra Birchmore's death. Does he regret it now? The Globe, that was printed on June 25th, 2025. The Globe reports that Farwell was the last person to see Birchmore alive on the evening of February 1st, 2021. Well, technically he was, because there's no surveillance that shows anybody else going in and out that would be visiting her. And she never came back out. So, yeah, he was the last one to see her alive. The article then claims the Birchmore cell phone stopped moving minutes after Farwell's departed. I don't know if that's a lie. This, the story adds a quote that investigators see a massive red flag whenever people of interest in death investigations decline to cooperate with DNA testing. Innocent people do not decline DNA testing. Um, I wouldn't decline. Um, I would still talk to my lawyer about it, but I probably wouldn't decline. But that's like saying people that don't talk are guilty. Like, oh, they hire a lawyer. Oh, they're not speaking. So that means they're guilty. Not necessarily. because you're supposed to remain silent. It would do all these people good and a better chance at a fair trial to shut their mouths. Granted, Matthew Farwell has shut his mouth, and he has the right to his attorney. He's doing what he should be doing. But he's a police officer, so he knows. He knows his Miranda rights. Okay. Displaying photographic and videotaped evidence to the public and conclusively drawing evidentiary meanings from those images before challenges to the admissibility and reliability of such materials can be tested in the courtroom places this case squarely within the realm of the seminal change of venue. Prejudice was presumed from pretrial publicity, a sample of which included reports that Shepard refused a lie detector test. Oh, that was in the Shepard v. Maxwell case. He was uncooperative with police. His family set up a protective ring around him. There had not yet been an inquest. The investigation had been inept because of the friendships, relationships, hired lawyers, a front page charge that somebody is getting away with murder, and an accusation that he had fathered an illegitimate child with an inmate. A responsible press has always been regarded as the handmaiden to or of effective judicial administration, especially in the criminal field. But freedom of discussion must not be allowed to divert the trial from the very purpose of the court system, to adjudicate controversies, both civil and criminal, in the calmness and solemnity of the courtroom according to the legal procedures. I agree. I mean, what we will see is your motion in limine to keep these videos out if they were obtained unlawfully. So when you start filing your motions in limine, we'll get to see what your side says about evidence that you are trying to exclude. That will be your part of the story, and we will be able to find out what y'all are saying about that and make our conclusions based on that. The more information we get, the more we can either check our current belief and decide if our current belief needs to change because of the updated information or if it's going to still remain the same. Some people are not open-minded, and I get that. But that's what, we need to be, is open-minded. We can hear it out. And then we can close our mind. And sometimes our initial thoughts and things that were being put out there, sometimes it's undisputable evidence. And he's not going to be able to explain it away. Just like in the Brian Walsh case right now. I am listening to everything. I am open. I am still at parts where I'm like, that's a problem. But as to whether I think Brian Walsh is guilty or not, so far in this trial, it hasn't changed my mind. I'm waiting to hear stuff that's like, but thus far, his story doesn't make a whole lot of sense to me. That doesn't mean I haven't listened to the evidence and seen everything, and I'm going to continue to listen to Walsh's trial, but it could be a lot like this one, where I think Farwell is guilty, and that I will still wait to see what comes out during trial. But my mind still might not change because he may, in fact, just be guilty. Reader comments. The Globe stories to date have more than 3,500 reader comments posted reflecting widespread publicity opinion that Farwell is guilty and must be punished severely. See footnote 8. The stories began more than 2 years ago, or before the federal indictment, and persist with every event in the case. Both the pace and intensity of its coverage suggest that the Globe's reporting and the prejudicial impact of its coverage will continue to exponentially as the case progresses towards trial. Interesting, I didn't get my news from Boston Globe. Have I read some of their articles? Yeah, but that's not where I've gotten my information. Exhibit 8 is the exhibit for samples of representative comments by the public, along with the number of comments which followed each story. Okay. The public comments to the Globe articles show a strong bias against Mr. Farwell. For example, public comments include definitive pronouncements of Mr. Farwell's guilt. He murdered her. The Internal Affairs report said Farwell was the last known person to see Birchmore alive. Exhibit 8 at 2. Is that not true? Like, I really want to know. Y'all are pushing that really hard. Oh, they said he was the last person to see her. Okay. I mean, that's not prejudicial for nobody to know. Like, right now, it's the last known person to have seen her. And are you going to be able to prove that somebody else saw her or talked to her? If you prove that, then we'll talk. But I think the surveillance camera would have picked it up. Others draw unfounded and unestablished connections to other investigations spearheaded by the Massachusetts State Police or local prosecutors. She was murdered by the father of her unborn child. Stoughton police officer Matthew Farwell. This is another suspiciously criminal investigation by state police assigned to Norfolk DA Michael Morrissey's office. Well, if the shoe fits. But you know what? There are other cases that have gone on in Norfolk, and the people have just been guilty. We're not saying that everybody that is connected with Norfolk is unethical. But there are some similar players that make us ask questions. There's some similar players in the Walsh case right now. That doesn't mean that Walsh isn't guilty. And it's really interesting to see in some of these cases when it's not a police officer how well things are done, which shows that they can do things correctly. And they choose not to in cases involving police officers. Now, do we know if the people in Canton knew that the address they were responding to was a girl that had been with a police officer? I don't know. But can we think that maybe that's why they're not pressing charges currently? That maybe initially when Canton went in, it wasn't a thing, and then they started to learn things, and then that's when Some corruption started, but initially it wasn't that. I don't know. Worse, some public comments demand the ultimate penalty of death in this case. The killer deserves the death penalty. Well, some people can feel like that. You did it to an unborn baby and somebody else. You didn't do it to just one person. What you did would be premeditated. A police officer who is a child rapist and then kills his pregnant victim and his future child. Yes, are those statements now not true? Yeah, those have been proven not to be. One part of that future child thing proves to be untrue. But do you know that the public still believes that it was his kid? Does majority of the public still believe that or know that? Or have they been updated and taken the new information into consideration when basing their opinion because they've kept an open mind? Death penalty material, if there ever was any. One reader simply replies, "Death penalty," followed by another comment, "Hey, I'm reading the affidavit. Perhaps Sandra Birchmore might have made a fine police officer." On pages 7 through 8 of the affidavit, we may see the deceased has already established as a fact that Farwell took her virginity on April 10, 2013. She wrote that date in a text message to Farwell, and he did not dispute her assertion. I am beginning to think that from the grave, her evidence may compel a conviction in this case. The death penalty could be too good for this guy. Let Sandra Birchmore haunt his dreams. Let him live a waking nightmare. Couldn't happen to a better guy. I mean, are you going to prove that he didn't take her virginity? I mean, even if he didn't, it's still disgusting what is alleged. Another reader disparaged Mr. Farwell and said he should die. Pig Farwell should exit prison in a green bag. Highly likely playing the cop card, he victimized, abused other girls and women. Now, I don't know if he's done anything to other girls or women. That I have no information on. At least with Farwell, Matthew. Um, Divine is another story. The examples continue. Firing squad. What a demonic thing. This Matthew Farwell is so gross in Norfolk County, Massachusetts. Most recently, when the defense counsel filed a motion requesting leave to file a motion to transfer venue exceeding the page limits, the Globe published a story within a half an hour, Exhibit 15, a selection of a separate public comments to that story include, "I would move to Worcester area to give him one less chance of appeal when he is found guilty. His trial will never be moved out of state. His contention is that all Mass residents can't be impartial until all evidence is revealed at trial. BS. The fact that his case is well known does not mean 12 jurors can't be fair and perform their duty. In colonial days, this vile murderer and child abuser would have been hung outside the courthouse post conviction. A nice oak tree would be fine." Well, alrighty then. Gross incompetence at the original death investigation location allowed this to happen. Can't wait to witness these cops testifying regarding their careful examinations and thorough follow up of information. If not for info from other teenagers and friends of Sandra, there would be no case. State senator proposes Massachusetts legislation against staged unalivings. The storm of local press coverage has delivered such great impact within the District of Massachusetts that it recently prompted Massachusetts State Senator Rebecca Rausch, which she is in the District of Needham, to propose a new bill aimed at identifying and investigating so called staged unalivings, citing Sandra Birchmore's death as an impetus for the legislation. The timing of this announcement of the bill immediately following the superseding indictment filed by or against Mr. Farwell is further evidence of its connection to and impact on this case. An October 29, 2025 Globe article by Laura Grimaldi regarding the bill, published less than 24 hours after news of the superseding indictment hits the press, and the same day as the press conference for the bill, not only asserts Mr. Birchmore's unaliving was staged, but again lays the groundwork for public prejudice against Mr. Farwell. Citing Sandra Birchmore case, new proposal seeks to address staged unalivings, Exhibit 12. This piece also draws comparison between the case against Mr. Farwell to a case in California of a defendant who was convicted of murder after trial. Notably, the trial featured the testimony of the government's anticipated quote unquote expert witness, in this case, Dr. William Smock. The article referenced a nonprofit organization, Alliance for Hope International, which is a sponsor of identical legislation in California, but fails to mention that Smock is the medical director for a program directly sponsored by and affiliated with Alliance for Hope International. Alliance for Hope International is discussed in this and other stories with no mention of its direct relationship with William Smock. See footnote 9. Compare Exhibit 11 at 7 through 8. Innocent people do not decline DNA testing, said Gwynn, who is a president of Alliance for Hope International, a California nonprofit that trains law enforcement to recognize domestic violence cases that are staged to look like unalivings or accidents. If you weren't completely innocent, why wouldn't you rule yourself out? Um, Exhibit 14, it's 7, describing former prosecutor Gwynn of Alliance for Hope International as someone not connected to this case who told the Globe that the unaliving declaration by Massachusetts authorities had all the tell signs of confirmation bias, emphasis added. I mean, it could have. Senator Rausch's proposed legislation exemplifies and epitomizes the extreme effect of local news coverage of this case. News media consumers in the district affected by the prejudicial coverage of this case have been convinced that Miss Birchmore's unaliving was quote unquote staged. The bill is direct result of this outcry. Doesn't make it false. Boston Herald. The Boston Herald has printed 27 articles referencing Matthew Farwell and 10 stories covering this federal case. Exhibit 13. On August 28, 2024, the Herald printed, as scandalous as the Karen Reed frame-up is, the Sandra Birchmore case may be even more horrific. And not just because both murders occurred in the same corrupt town, featuring largely the same cast of bumbling corrupt cops, ellipsis. The state medical examiner ruled Birchmore's death an unaliving. Wink, wink, nudge, nudge. How long would it have taken them to string Karen Reed up, just like they did to Sandra Birchmore? I don't know if that. Well, it's not the same scenario. Both of them are not great, but for way different reasons. On September 1st, 2024, the Herald, in its News, Crime, and Public Safety section, published the grisly details on how former Stoughton cop allegedly groomed, arped, impregnated, and then killed a young woman he first met when she was 12 years older. are darker than prosecutors could possibly describe in a press conference announcing his arrest. Well, I mean, the thing is, while you as a defense attorney and Farwell may not see what he did as graping, the fact is, if he had any type of sexual contact with her when she was a minor, that is graping because she can't give informed consent. Whether you say, no, she said I could do it, like I didn't, it wasn't a, she told me no, like, because some people that do this type of thing will be like, well, they didn't say no, so it wasn't like I actually, like, just forced her, and it's like, no, that's where the grooming aspect came in, because you didn't technically force them, but they are not able to give informed consent, therefore, you do not have consent or permission to do that to a minor, which means grape. So, we'll see his argument for any of that, um, see how that goes. I don't think he should testify in his own trial. He is one that I do not think needs to get on the stand. It's not going to go well for him, which I don't think he will. I think he will not testify and let his attorneys do everything. On August 28, 2024, the Herald referred to Mr. Farwell as a depraved former Stoughton cop. And from an editorial on September 15, 2024, by the Boston Herald editorial staff, the paper noted that it is hard to imagine a more clear-cut case for enforcing federal laws for protecting unborn children than this one, when the very existence of an unborn child was the very evidence against this monster. I agree. Whether it was his child or not, she was still pregnant, and if he's the one that killed her, which all evidence points to he did, uh, yeah, this is why. All because he didn't want his secrets to get out. He didn't know for sure that that baby wasn't his. He hoped it wasn't, and he was gonna keep telling himself that it wasn't. But he wasn't sure. He had to, in his mind, believe that this child is his. Or there's a possibility of it, because why would he have done this if it wasn't his? He can say, "I knew it wasn't mine," all he wants. But to me, if he didn't think that there was a possibility that this baby could be his, he would not have done what he did. Because he could have sit there and say all day long, "That's not my child. It's not my child." And he wouldn't have had to worry about it. And he would have known that DNA was gonna show this, and then it wasn't true. I think there's a possibility that even if that would have come out and he would have been tested and found out it wasn't his, or could say, "No, it's not mine, DNA will prove it," I think people would have still looked through his messages. But the thing is his wife is still with him right now. Will she divorce him after all this is over with? I don't know, but right now she's still with him. On September 15, 2024, the Herald featured a full-page cover for its Sunday edition entitled Life for Life, and printed over a photograph of Sandra Birchmore and a caption at the bottom, "Unborn victims of violent act not used in Birchmore murder case. Why not?" Recently, the Herald even reported that when Mr. Farwell was not going to attend the arraignment in person, and in the same article stated that he killed their baby, quote unquote. I know why he's putting that in there. We've already stated it. It's because that is one of the untrue statements that is out there, but the thing is nobody knew it was untrue at the time. That's what it was alleged. And then more information came out. More Boston Herald articles included in Exhibit 13 local television coverage. Local television coverage on the federal charges began as early as August 28th and August 29th of 2024. NBC's footage depicts the arrest of Matthew Farwell by FBI SWAT officers, as well as video clips from the United States Attorney's press conference detailing the 45-page FBI affidavit against Mr. Farwell based on the court paperwork. The reports repeats the government's version, which detail against Mr. Farwell using terms such as groomed, essay, exploit, and grape a child, and the claims that Birchmore's actions before her death proved that she would not have committed unaliving. See footnote 10. Just a link to the article. Okay. WHDH's footage opens with the accused killer murdered a woman he got pregnant in 2021. The report outlines the prosecutor's version of events that Mr. Farwell started an illegal sexual relationship with Miss Birchmore when she was just 15. Throughout the reports reference court documents showing a photo of the Congrats We're Going to Be Parents poster, as well as details of excerpts of conversation they attribute to Miss Birchmore and her friends, and to Miss Birchmore and Mr. Farwell. The video also shows clips of Stoughton Police Officer Chief Donna McNamara, which we have gone over McNamara's statement that she put out about all this. I have a video on that. It's in the Sandra Birchmore playlist if you want to go watch that. Discussing Birchmore and her trust of law enforcement. See footnote 11. 11 and 12 are just news article links. Okay. CBS video begins with former Stoughton police officer charged in the killing of a pregnant woman. The video shows various pictures of Birchmore, including one with her cat multiple times. The reporter states that Mr. Farwell is accused of grooming Miss Birchmore, and they have been following the story for years. There are clips from the United States Attorney's press conference calling Mr. Farwell depraved and discussing the physical size difference between Miss Birchmore and Mr. Farwell. There are still from the motion and memorandum in support of pretrial detention, including texts between Miss Birchmore and her friend. The video also shows protesters of the Justice for Sandra Birchmore supporters. A screenshot was shown during the news story showing a text bubble attributed to Miss Birchmore saying Mr. Farwell had looked in her closet. The coverage then provided that Sandra Birchmore was found dead in front of that closet a week later as a part of a staged unaliving. Okay. You know what the news articles could do is the ones that say Farwell got her pregnant, they could go in and edit that say is recent, as of this date, it has been confirmed that Matthew Farwell is indeed not the father of the unborn baby that Sandra Birchmore was pregnant with. That could be updated in those news articles. Does it necessarily correct the issue that the defense is arguing here? No, because most people aren't going to go back and reread that article. So it's already done the damage, basically. But if they are following, these places, I believe they have reported that as well. So they would have the new information along with that. So, if somebody wanted to change a venue, this is not a surprising motion to me that he would ask for this. I don't think it needs to move out of the whole entire state of Massachusetts, though. Are you gonna move it to Texas? That's not gonna go good for you here. Don't come here. I don't know that it's gonna be good in New Jersey or New York or, you know, Pennsylvania. I don't know that those are gonna be any better. Um, but we'll see how it goes. He does have an argument for it because there has been coverage of it, but I mean, Diddy was able to have a federal case, um, not in Massachusetts, but I mean, they found people who didn't know about the Diddy stuff, supposedly. They've done federal cases of plenty of famous people all the time that are way more famous than Matthew Farwell. Local station WCV began reporting on Farwell's indictment by 5:28 a.m. on August 29, 2024, and a news report begins with Birchmore's former martial arts instructor stating the fact that her perpetrator is facing justice is reassuring. The video shows clips from the United States Attorney's press conference describing how Birchmore survived years of grooming, statutory rape, and SA violence, all at the hands of Matthew Farwell. There is a photo of a "Congrats, we're going to be parents" poster, along with mention of the Stoughton PD internal investigation. The report ends with the penalty: Mr. Farwell is facing life in prison or the death penalty. See footnote 13. My guess is that is just another link. We'll see. In sum, the repeated reporting in this case has led the community, as demonstrated through such notables as editor of the Boston Globe and Massachusetts State Senator, and the thousands of negative public comments, to conclude that Mr. Farwell killed Miss Birchmore and staged her death to appear as an unaliving. This series of events has created a reasonable likelihood that prejudicial and overwhelming news coverage prior to the trial has prevented a fair trial in this district. Argument. The Constitution requires transfer of venue here, given the rights at stake and the scope of the prejudicial publicity. Prejudice should be presumed, and transfer should be granted to safeguard Mr. Farwell's constitutional rights to due process and to ensure a fair trial. Additionally, under the Federal Rules of Criminal Procedure 21A, there is reasonable likelihood that the pretrial publicity will prevent a fair trial here. The judge could just, say, hey, I'm going to reserve the ruling on this. If for some reason we can't find a jury, then we will look at moving it. And the thing is now is that a lot of people can is that we have people before could just say, no, I don't know anything about that. Never heard of it, and they could lie. Nowadays, if people are really informed about it and following the case and stuff like that, and they're on social media, their social media is going to give them away. And so it's easier to find out if a juror is being honest or not, because the lawyers can go look at their social medias of these jurors if they can find them to make sure that they are telling the truth. All right. Mr. Farwell's constitutional rights. Mr. Farwell contests his guilt. The Sixth Amendment guarantees criminal defendants the right to trial by an impartial jury. And then they cite a case. The Fifth Amendment guarantees that no individual shall be deprived of life, liberty, or property without due process of the law. In this death eligible case where all parties still await the Attorney General's decision on whether the death will be authorized as an available punishment. The Eighth Amendment prohibits cruel and unusual punishment from being inflicted upon the defendant. I don't think anything cruel and unusual is happening to Matthew Farwell. Maybe talk to Richard Allen before you claim that he's being treated with cruel and unusual punishment. Yeah, the fact whether they are actually going to be seeking the death penalty or not, from my understanding, has not come out yet. That or they made the decision not to. So, but as of the 17th, it had not been determined. Extraordinary local prejudice would prevent a fair trial. The trial must be transferred to another district. The theory of our trial system is that the conclusion to be reached in a case will be induced only by evidence and argument in open court and not by outside influence, whether of private talk or public print. The United States Supreme Court has given practical meaning and definition to these constitutional provisions, particularly the Fifth and Sixth Amendments, in the context of venue in its seminal decisions. And they cite case law there. Put simply, a criminal defendant must receive a fair trial consistent with constitutional due process. Shepard v. Maxwell, which is a very well-known case. It's cited quite a bit. Specifies that a fair trial requires a trial by an impartial jury, free from outside influences. The burden of establishing presumed prejudice can be met despite juror assurances of impartiality and where potential jurors have only read or scanned newspaper articles. A case involving the Enron CEO. Oh my God, I haven't heard of Enron in so long. I forgot about Enron. Man, Enron was something else. Charged with a massive fraud scheme, the federal Supreme Court distilled several principles from its cases involving pretrial publicity and presumption prejudice. With regard to two of those factors, the court noted, although news stories about Skilling were not kind, they contained no confession or other blatant prejudicial information of the type readers or viewers could not reasonably be expected to shut from sight. Rideau's dramatically staged admission of guilt, for instance, was likely imprinted indelibly in the mind of anyone who watched it. The defendant's own confession is probably the most probative and damaging evidence that can be admitted against him. Internal quotation marks omitted. Pretrial publicity about Skilling was less memorable and prejudicial. No evidence of the smoking gun variety invited prejudgment of his culpability. A jury may have difficulty in disbelieving or forgetting a defendant's opinion of his own guilt, but have no difficulty in rejecting the opinions of others because they may not be well-founded. In the case at hand, the press continually and insistently repeats the government's claims of Mr. Farwell's guilt, rooted principally in the FBI affidavit filed before Mr. Farwell's arraignment on August 28, 2024. To be sure, Mr. Farwell has steadfast in his plea of not guilty, and he has not had a chance to challenge the materials set forth in the 45-page FBI affidavit, DE91. But that has not stopped the media from broadcasting photographs of Mr. Farwell entering and leaving her apartment complex, according to the captions, or from pronouncing that Mr. Farwell got into an argument with Birchmore, that he was supposedly with her when her cell phone recorded its last steps, and that he staged her unaliving, leaving minutes after, and that he was the last person to see her alive. Like Rideau, these quote-unquote facts are likely imprinted indelibly in the mind of anyone who has ever seen or read them, as they have been repeated, set out in the media coverage here. Well, if you can show me where that stuff is not true, then okay, I'd be open to it. Find jurors that are open to that stuff. In Skilling, the Supreme Court further observed that unlike cases in which trial swiftly followed a wide reported crime, for over 4 years elapsed between Enron's bankruptcy and Skilling's trial. Although reporters covered Enron-related news throughout this period, the decibel level of media attention diminished somewhat in the years following Enron's collapse. In the present case, the Global's coverage began 2 years before Mr. Farwell's federal indictment, continues to this day, and will increase substantially as trial approaches. I don't disagree with him there. That is probably what's going to happen. The Herald will likely continue to write stories, as will the local television news stations. Not wrong. The above Supreme Court decision recognizes that when there has been persuasive media coverage of a case, and the quality of the coverage creates a reasonable likelihood of perception that a fair and impartial trial cannot be had in the current district, prejudice is presumed and the venue must be changed. In the above trio of cases, transfer is encouraged where the threat of prejudice lurks and the venue may be changed proactively. Where there is reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until the threat abates, or transfer it to another county not so permanent with publicity. There is no sign that coverage will abate here. Okay. I don't care. Give him a change of venue. I don't give a shit. Like give him a change of venue. There's the only one you're gonna get, in my opinion. In Murphy v. Florida, 1975 case, the Supreme Court distinguished mere familiarity with the petitioner or his past from an actual predisposition against him, juxtaposing large factual publicity and that which is invidious or inflammatory. In Murphy, the Supreme Court found the general community atmosphere was not inflamed and that the publicity itself was largely factual in nature. By contrast here, the publicity is not limited to factual presentations, and the comments noted go far beyond a familiarity with Mr. Farwell, instead revealing an actual predisposition against him. The FBI affidavit, which forms the predicate for much of the reporting, is filed with irrelevant and inflammatory characterizations of Mr. Farwell himself. The coverage has led the readers to conclude that Mr. Farwell is guilty and to call him vile names and to cry out for severe punishment, including death. Redu versus Louisiana from 1963, the Supreme Court wasted no time in presuming prejudice where the record established that a confession by the accused had been televised pretrial. The court arrived at its conclusion of presumed prejudice without examining the transcript of voir dire for actual prejudice. The court was not concerned with whether any particular juror had seen the television interview. Instead, the court emphatically observed, "We do not hesitate to hold," without pausing to examine the particularized transcript of voir dire examination of the members of the jury. The due process of the law in this case required a trial before a jury drawn from a community of people who had not seen and heard from Redu's televised interview. Farwell doesn't have any of that, but yep, I can see why they moved that one, especially back then. Noting in Redu, the court did not examine the voir dire for evidence of actual prejudice because it considered the trial under review but a hollow formality. Another case, the district court took heed of the necessity to resolve venue issues prior to jury selection because a failed attempt to select a jury would itself cause widespread public comment, creating additional difficulty and beginning again at another place for trial. The McVeigh court also noted because of the penalty of death is by its very nature different from all other punishments in that it is final and irrevocable. The issue of prejudice raised by the present motions must include a consideration of whether there is a showing of predilection towards the penalty. Decision defined prejudice as an adverse judgment or opinion formed beforehand or without knowledge of examination of the facts, and B, a preconceived preference or idea. As noted in comments to and the content of news articles that have been circulated in this district, presumed prejudice exists. Can't pronounce that, but has to do with the Boston Marathon bomber decisions, although the law on the venue in the First Circuit Court was most recently been shaped by its decisions related to the Boston Marathon bomber. Both the posture and nature of prejudice evident in the case against them are readily distinguishable from Mr. Farwell's case and do not foreclose the relief requested herein. For example, First Circuit Court in 2015, the First Circuit addressed a request for a writ of mandamus and discussed whether the district court clearly and indisputably erred in conclusion that venue need not have been transferred, and the proper remedy was time and fulsome jury selection. The court held that an extraordinary remedy was not required in that case. On appeal, they noted as important consideration on the venue transfer motion that the guy for the Boston Marathon thing did not contest his guilt. Thus, the bulk of the publicity involving his case and prosecution was true. Okay. So that's going to be different here, where they're saying in the Boston Marathon one, he wasn't denying that he was that person. Therefore, the statements, were not considered false. So if anybody had seen them, they weren't seeing untrue things. And he's saying that, well, in that case, they didn't do it. But in this case, Farwell is disputing things because he is saying he is not guilty. And so do not compare it to this one, because he says it's different because of the guilt and not guilt pleading. Most of the publicity was true, something we know from his guilt admission and his lawyer's guilt phase opening and closing statements. Notably, Boston Marathon guy does not say he would have raised an innocence defense in another venue. So after the first day of trial, a juror from Boston and one from California would know essentially the same things about the case, even though the California juror would have seen less publicity. Yeah, we saw that here in Texas too. Even though the California juror, okay, internal quotation omitted. In contrast, Mr. Farwell has maintained his innocence. Additionally, the First Circuit wrestled with the fact that because the publicity was so overwhelming, it would be difficult to find a suitable location not so infected with pretrial publicity. Yeah, it would have for that case. We note, too, that this is not a case where almost everybody locally knows something, and very few elsewhere know of it. As noted by the First Circuit, the Boston Marathon bombing would likely be viewed as an attack on all of America, as himself did, thus negating any advantage in changing venues. Unlike the widespread nationwide coverage presented in that case, the issues present here are of overwhelming local interest. The pretrial publicity focusing on presumed guilt of Mr. Farwell and visual displays of his purported presence at the scene of the death have resulted in a presumption of prejudice in this case, requiring a transfer under the Constitution. Like I said, I don't care if they transfer this case. They may not want to spend that kind of money to do it in another case or in another place, but it would just be different jurors from a different place. Um, and he couldn't say that they're not a jury of his peers because he asked for it. So uh, I just don't think it's going to matter. So to preserve, you know, his appellate rights and stuff, I mean, granted, it's still going to be the same people that are prosecuting the case. That doesn't change. It's not like a new prosecutor comes in because it's moved to somewhere else. Let me just plug my computer in real quick. This document was longer than I expected. Let me see here. Okay. So, venue must be transferred under Federal Rules of Criminal Procedure 21A. Rule 21 of the Federal Rules of Criminal Procedure requires a transfer of venue if the court is satisfied that so great a prejudice against the defendant exists in the transferring district that the defendant cannot obtain a fair and impartial trial there. To prevail in a motion under Rule 21A, the defense need only show a reasonable likelihood that prejudicial news prior to the trial will prevent a fair trial. Citing cases, no error in denying motion for a change of venue pursuant to Rule 21A, where defendant failed to show a reasonable likelihood that pretrial publicity would prevent a fair trial. It is important to consider that much of the source of this pretrial publicity stems from the publicly filed FBI affidavit and other law enforcement and governmental sources. None of the pretrial publicity has been initiated by Mr. Farwell or his defense team. That is true. Mr. Farwell has stayed away, like he don't even come to court. He just stays, I guess, in his jail cell, awaiting trial. Supra noting that in assessing a defendant's 21A motion for change of venue, the district court may take into account, inter alia, the extent to which the government is responsible for generating the publicity and the extent to which the publicity focuses on the crime rather than one individual defendant charged with it. Maldonado Rivera upheld the district court's denial of Rule 21A motion, where the court found, among other things, that the government's press release had contained only authorized factual materials which were not prejudicial, and some of the pretrial publicity had been generated by the defendants themselves. So he's saying, if y'all look at this case, this is not like this because Farwell has not generated any of this publicity himself. It has been all of everybody else. In United States versus Moody, a case was transferred from the Atlanta metropolitan area to the District of Minnesota. The defendant made a showing in Moody that local media spread prejudicial information about the defendant's past criminal record and statements by federal investigating officers about the defendant's guilt. The court's opinion focused on publicity in the Atlanta Journal and Constitution, including this statement. Much of the evidence against Moody is circumstantial, but investigators say Such cases are frequently successful because they are built from interlocking pieces and do not depend on a simple smoking gun. The court pointed to another article which read, "This is a coffin that has 1,000 nails in it," a federal law enforcement official said of the case against Moody. The Moody court printed in a footnote the entirety of a 14-paragraph article from the Atlanta Journal Constitution entitled, "Here's Evidence Against Moody," noting the information came from the federal investigators. The newspaper article outlined factually the evidence against Moody. The court found it important that prejudicial information reached the public through news accounts, which included references to defendants' past criminal record and convictions, the government's evidence against the defendant, the statements of federal investigating officers concerning the defendant's guilt. The Globe's 18-page single-spaced article here, Exhibit 9 here too, bears substantial similarity to the problems addressed with the transfer by the Moody Court. The Moody Court found under Rule 21A that transfer was warranted from the large metropolitan area of Atlanta to Minnesota. A lawyer of the attached exhibit shows repeatedly and similar prejudicial and inflammatory publicity about Mr. Farwell himself and the nature of the quote-unquote crime that the press, the public, and even Massachusetts state legislature has assumed Matthew Farwell has committed. The press has been an arm of the government in spreading a one-sided prosecutorial version of the case. To preserve Mr. Farwell's right to fair trial and presumption of innocence, we request a transfer of this case from the District of Massachusetts. Okay. They've decided that request transfer to the District of Rhode Island. So I mentioned I don't think it would be different in Jersey, New York, Pennsylvania. I don't know that it's going to be any different in Rhode Island, but they are saying that even though Rhode Island is fairly close to Massachusetts, we would be okay with it being done in Rhode Island. So, through the form would not be as convenient to the prosecutors or perhaps many witnesses, though many witnesses may in fact be as conveniently situated. Mr. Farwell is housed 7 miles from the courthouse in Central Falls, Rhode Island, and the transfer there would be more convenient for Mr. Farwell and likely the U.S. Marshals Service. Furthermore, Rhode Island is a suitable location for transfer of this case as it is still close to the alleged locations at the issue in this case. Providence has its own airport and an Amtrak station convenient to the courthouse. Most importantly, Providence has its own news coverage and lacks the local and personal interest in the volume of personal, prejudicial, and inflammatory coverage paid to this case and Mr. Farwell by local press in Massachusetts. So I don't think Rhode Island is a stretch to ask for. Like I was saying, it would be a bit of a stretch to like move it to Texas or something. And if there's a case where they moved it from Atlanta, Georgia, down in the south up to north in Minnesota, like 2 different worlds, then Massachusetts to Rhode Island is not that big of a jump. And I think it's a reasonable request. You know, because they should be like, no, nothing up north, nothing near the 13 colonies, nothing. We need to get away from the 13 colonies, get away from the Commonwealth, go far away. But they're being reasonable and staying in that area. So it's not a crazy ask. Conclusion and request for oral argument. For the foregoing reasons, and pursuant to the Fifth, Sixth, and Eighth Amendments to the United States Constitution and Federal Rule of Criminal Procedure 21, the defendant requests that this court transfer venue in this action to the District of Rhode Island, consistent with Local Rule 7.1D. Undersigned counsel requests that the Honorable Court hold a hearing and permit oral arguments on this motion pursuant to Local Rule 7.1A2. Counsel conferred with the government and understands that the government opposes this motion. I mean, and they can oppose it all they want. And it is signed, respectfully submitted by Kimberly Stevens, who works for the Public Defender's Office. So she is doing her job. She's certified that she sent this electronically to all the parties and filed it within the court. So, I don't think she's doing a bad job. I think she's doing her job as a lawyer. I don't think that he will be able to claim ineffective assistance of counsel. But I mean, is this gonna really affect the case as far as what comes out? No. I don't think it's gonna matter if they change the venue or not. Give it to him and, let's continue on. Yeah, it's gonna be a little bit, inconvenient for some other people, but I don't even know how long of a drive that is, because it's crazy to me that you could be in different states within a matter of, you know, short time, up there, because I don't know what that's like, but that is the motion that Farwell is wanting a change of venue and our continued coverage in the Sandra Birchmore case and wanting justice for her and the unborn child. And Matthew Farwell seems to be the guy, and he's going to have to face the consequences. While he may not, while all the information out there may not be completely factual, we keep our minds open, continue to listen, because at the end of the day, if they have the right guy it, and he did it, it's not going to hurt anybody to be open-minded, because that makes sure that we didn't just close our mind off and we can be like, no, like we listened to everything everybody had to say on that side. We listened to him and his lawyer tell his tale, which makes no sense and it doesn't align with the evidence. He's guilty and he deserves the consequence. And that's how we want trials to come out. So while most of us, we have our belief, um, doesn't mean there's going to be something that you're like, oh my God, like the whole Farwell not being the dad. The thing is that doesn't change what Farwell did or is alleged to do, right? Kinda makes it even shittier that you went and did all this instead of just waiting to find out if you were the father or not. You just couldn't wait that long. You couldn't deal with this for another 8 months, 7 months, however long, until you could have been cleared of not being this baby's father. So, you know, whatever comes of this will come of this. And I will be here bringing you all that info as it comes out. So please like, subscribe, turn the notification bells on so you never miss a video when we update the case and continue to follow Sandra Birchmore. That is it, and I will see you guys next time. Bye.